SJC-12321, Commonwealth fee, Edwin Padua.
Mr. Bauer, good morning.
Good morning, and may it please the court, Max Bauer on behalf of Edwin Padua. I'm joined with Joshua Werner, who was counsel at the hearing back in 2014. This case is controlled by the Simmons footnote 2, as well as Doe and Delgado that make the exact same point. There can be no judgment of conviction without a sentence. In this case, there was a filed case. There was a remand to determine if there were any grounds for sentencing. Even with the benefit of that remand, there was no justification, and the appeals court correctly determined that there was no ground for a sentence, but paradoxically and contrary to Simmons footnote 2, upheld the conviction and remanded for resentencing.
But isn't there a difference between a conviction and sentencing for that conviction? So, I mean, can't we separate those two issues?
You can separate it, but it's beside the point. As this court said in Simmons just over a decade ago, the phrase to place conviction on file is internally contradictory. And while there can be a difference between a conviction, meaning simply the finding of guilt, and a judgment of conviction, including the sentence, in the context of a filed case, there cannot be a judgment of conviction, which is the key question here.
Yeah, I've lost you a little bit. We do many times say we affirm the conviction, but we remand it for sentencing.
That is true, and my brother, actually the predecessor to the ADA before
Not your
us.
brother?
Well, he still is.
Sort of your brother.
I'm
Okay.
referring to a different ADA.
His predecessor brother.
For what it's
okay.
worth.
His
but,
older brother.
have cited some cases where the sentence is vacated, but the conviction is affirmed. Every single one of those cases, there was no dispute that there was some basis for some sentence. In here, there is no basis for any sentence. Even asking the trial court judge, what was your basis? He had no recollection. That puts us right into Simmons footnote 2. And this is, as this court said, well-established law that with no sentence, there is no judgment of conviction.
So why is the proper course? Now, I gather Mr. Padua has completed his sentence.
Yes, he has, absent a ground for doing so.
So we'd have a double jeopardy issue if we were to, if any judge were to impose a greater sentence.
Yes.
Since he's completed it. So why is the proper course not simply to say we affirm his conviction, but there's no need to be resentenced because he already has completed his sentence?
Well, you'd be getting it half right. The problem is, well, I agree there's no need for remand. The issue here, and this is why this case was not moot and this was not disputed, the Commonwealth did not appeal this finding. This case was not moot because there was still an interest in getting the judgment of conviction off Mr. Padua's question. That's the only live issue before the court today.
But didn't he plead guilty to these two counts of threats?
He pled guilty and he got the cases filed, and all that I am asking is to maintain that exact disposition. It would still be a finding of guilt, but it would not be a judgment of conviction.
But if I'm correct here, the judge sentenced him on the filed case, and there was a challenge as to whether that could appropriately be done, and it was remanded for purposes of the judge articulating the reasons for the sentence, and the judge could not recall, and now the sentence has already been fully completed. But if the judge was correct in sentencing the defendant and did not violate any of our rules with regard to cases placed on file, why should the conviction on that charge not stand?
Are you referring to a judgment of conviction? Because that's the key.
Judgment of conviction.
Yeah, so
I guess
the
the only consequence I gather is what happens if he gets charged with another crime, or if he's to be, I'm not sure whether
Right.
he's subject to immigration issues, but.
So that question was phrased as a hypothetical, which is belied by the facts in this case. if there was some ground for sentencing. That's your question. But even with the benefit of a remand saying, was there ground for sentencing, the trial court judge says, I do not recall. That was after the appeals court says in the December 6, 2016 order, we need to find out if there was a ground because we don't see one. After the judge responds by letter, the appeals court says, okay, now we see that there was no basis from that trial court judge's recollection complying with the rules on filed case reviving and specifically Rule 28E. So then we have the actual outcome here, which is no justification whatsoever for any sentence. That takes us back to Simmons footnote 2, no sentence equals no conviction. Does that clarify it for Your Honor? I think it's that simple, but I understand that there's a few steps that have to be achieved to get to that point. I'm submitting that everything that I said is the background of this case.
Okay, thank you.
Thank you.
Mr. Mark, is it as simple as your brother says?
I think perhaps not quite. Well, I think it's simple. How about that? So we can agree on that. The premise of my brother's argument is that there's significance to footnote 2 of Simmons that I think it simply does not have. And part of the reason I think it doesn't have that significance is that you'll note that in Simmons itself, what happened was that a case that had been on file, the sentence was vacated and it was remanded for resentencing. If my brother is right about footnote 2, that should have been impossible. That shouldn't have been a possible result. So he has to be misreading the footnote. And I think he is. I think he has smuggled in an additional premise that actually doesn't follow from anything in the language of the footnote. And that premise is that a filed case, even when it's brought forward and a sentence is imposed, retains a kind of provisional status such that if it is later determined that there's a problem of some sort with the sentence and it needs to be remanded or the sentence needs to be vacated and remanding, it then snaps back to its filed status. And I just see nothing in the footnote or Simmons or any other case that would require that result. Simmons says something, I think the footnote says something quite uncontroversial. I would say that the footnote seems to treat as synonymous conviction and judgment of conviction. And we cite in our brief Lockwood that suggests that you could draw a finer distinction at that. But treating Simmons as making that equivalence, nothing in the footnote is all that exciting or controversial. It just says that you can't put a judgment of conviction on file because a judgment of conviction has a sentence. And by definition, a filed case doesn't have that. So the footnote was not an attempt to create an ontological mystery about the status of filed cases. It was just an attempt to clarify some language because...
Well, in fact, it says it's just an error in nomenclature.
An error in nomenclature, yeah. It's a semantic clarification, not an attempt to create mystification about the status of filed cases. So I think there's, with all due deference to my brother and the energetic argument he made, I think there's nothing here. I don't think I don't think there's anything about a filed case once you bring it forward that continues to be, provisional or unique. It's just another case at that point. Once it comes off the file and you sentence it, it's like any other case. Now, it's true that, as here, there are specific provisions that need to be met in order for the sentence to be valid, and a question arose about whether that had been met. But so we address that. We, as the appeals court did, you vacate the sentence, you affirm the conviction, and you remand to get the sentence proper. I don't see a problem with that.
Now, should we be doing that here where he's finished his sentence?
Well, accepting the defendant's premise that it is possible that you could decide that in his favor that the filed case can't be, once the sentence is taken away, the filed case is not there anymore, then the case isn't...
It's there. He served time, or he served time on it.
Yes.
He's finished completing that time.
Yes.
So if it were to go back to the judge, what could the judge do?
Well, so if it goes back to the judge, you've already accepted that the case is moot. My brother's argument, I think, is that it doesn't go back to the judge because the resentencing is inappropriate per se. I'm trying to make the,
Well, but I'm
be
trying to
fair
figure
to
out
the.
what, I mean, are you asking that it go back to the judge?
Yes, I think that's let's just do what the appeals court asked to be done here, which is send it back to the judge to do correctly what he apparently didn't do or couldn't remember having done the first time.
Which is what?
Which is to consider two factors. One, the overall original sentencing scheme and the underlying conduct in the case that is in the threats cases, the two threats cases have been brought forward.
What if the judge decides, oh, you know what, that we shouldn't have done that?
I think it's within the judge's power to refile the case. I know of no reason why that can't be done. So I think that continues to be an option for the judge on the remand.
I'm sorry, to refile it, meaning put it back?
I think you can go back in the file. I know of no case that says you can't put the case back in the file. Now, I think you're about to say, but he served the time, and that's true, but to the extent the defendant continues to have an interest in the case, to the extent that this is not moot, it's all about the continuing status of that case on his record. And he says, I would much prefer that the case, it'd be guilty filed and not, a judgment of conviction, 6 months, threats.
Okay, so you're saying that we should send it back to the judge because there's a possibility that the judge would say, I goofed and I imposed a sentence based on inappropriate criteria, and therefore I'm going to admit that I goofed and then refile the case.
We're past that point. He's already said, I can't remember what happened. So he's not going to say I goofed. We're already at the point where he says, I don't know whether I goofed or not.
Okay, so how does it get refiled?
It is, I think once it's back in front of the judge, I think one of the options he has is to put it back in the file. I think just as if it's
Okay, so that's one option. What's the other option?
Is to impose some sentence, which includes a kind of, the threats statute itself has a kind of diversionary option, right? You can impose a recognizance.
Wouldn't that be punishing him twice if he gave him a different sentence from what he already?
Well, it would be, whatever it is would be deemed served. Yeah.
Okay.
So yes, that would be problematic. But so Your Honor, am I arguing strenuously that we should?
He couldn't put him back on probation because that would be double jeopardy.
No, it would have to be, everything would have to be deemed served. He's already served the maximum time on threats, which is 6 months.
So isn't that just a waste of time to send it back? So basically, whatever he could do is deemed served, can't put him back on probation, probably can't file something he already served time on.
I'm not arguing strenuously for this as a better option. I'm saying it's a permissible option, and as it does at least, even if even supposing you agree with the Commonwealth that the defendant's argument is not correct, I think the one thing that the remand would do is it would allow the sentencing judge to refile the case, which is essentially the result he wants anyway. So if I'm wrong about that, then no, I think you're right. There's no point in sending it.
But I'm just trying to. This is an unusual case. So
Yeah.
let's assume we send it back to the judge. The judge has said, "I don't remember the case. It was years ago." And how would the judge?
The judge would have to. You could send it to a new judge. It doesn't matter at this point because the judge who originally imposed the 6 months on the threats has no present recollection of why he did that. So
Right. Okay.
if it's going to be resentenced, it could go in front of any judge, and that judge would have to, subject to the constraint that essentially that no new punishment could be imposed, would have to make the considerations that are required, which is overall sentencing scheme, underlying conduct, and then impose whatever the new sentence would be.
So you're saying we should send it back to the judge and tell the judge that you can refile it, you can impose a sentence which you must deem
to have been served.
served.
Yes, I think those are the two permissible options.
Choices. Those are the two choices.
I think that's right.
But you're saying there still is a choice that would mean that the conviction would not be counted as a conviction against the defendant.
I could be wrong about this, but I have not found a case that says you can't refile. If you cannot, then there is no point in sending this back. If that's not an option, I don't see that the case is not in fact moot.
And although the judge has no memory, is what you're saying to us that a judge potentially could say, I can't say I did it right, and since I can't be sure I did it right, the better course is to refile?
So I think the judge at this point is just to consider the matter anew, and in considering the matter anew may say, I see no reason to impose any sentence here, I'm just going to refile this.
Okay,
Thank you.
all right, thank you.